much for introduction. Thank you. So, military crimes. When analyzing the issue of military crimes, it is necessary to first outline the subject of possible consideration by indication that under the current regulation, crimes subject to the jurisdiction of military court, so-called military crimes, should be considered. The concept of military crimes should be identified with the catalogue defined the legislator using the objective, subjective, and objective-subjective criteria. This catalogue was included in Article 647 of the Code of Criminal Procedure. Okay, that's it. Pursuant to Article 647.1 Code of Criminal Procedure, cases involving a crime committed by a soldier in active military service are considered military crimes when, first, those which are described in chapters 39 to 44 of the Penal Code, second, those which are directed against a military authority or another soldier, third, those which occurred in connection with the performance of official duties within a military facilities or designated place of residence to the determinant of the military or in violation of the obligation assigned from military service, and four, those which are committed aboard during the use or stay there of Polish armed forces. Military crimes are related to the difference assigned from the general provisions established in the Criminal Code for soldiers. These provisions are contained in Chapter 38 of the Criminal Code. The legislator has introduced additional countertypes for perpetrators who are soldiers, soldier perpetrators. Countertypes are circumstances that exclude the illegality of the given behavior. These are first asked within the framework of an order, Article 318 of the Criminal Code, and second, act with the framework of the ultimate military necessity, that is, to force obedience by another soldier in order to execute an legitimate order, Article 319 of the Criminal Code. The general provisions introduced different solutions regarding the penalties and punitive measures imposed by the military court in the case of a conviction for a military crime. So, in Article 322 of the Criminal Code, the legislator regulated the penalty of military detention. Military detention. This is a kind of prison sentence with the difference that it is carried out in a designated penal institution and during the time the convict is subject to military training. In Article 323 of the Criminal Code, the legislator regulated in a different way than Article 34 of the Criminal Code the principle of carrying out the penalty of restriction of liberty for soldiers, indicating that they are carrying out this punishment by staying at a designated place at the disposal of a superior during the period from the end of their duties for 4 hours, 2 days a week. In addition, this can be combined with a reduction of 5 to 15% of the monthly basic allowance for the specified social purpose. This provision assumed that if a soldier is sentenced to restriction of liberty, he cannot be appointed to a higher military rank or appointed to a higher official position, nor can he take part in ceremonies and parades organized in military unit or with the participation of the unit. With regard to the content of Article 3 to 4 of the Criminal Code. As a punitive measure against a soldier, the military court may order exclusion from professional military service. This may occur in a situation where the soldier, in committing an offense, has grossly abused his power or has shown that the continued performance of the service engaged the essential goods protected by the law. Another characteristic punitive measure that may be imposed in the case of the commission of military crimes is degradation. It consists of the loss of the military rank held and the return to the rank of private. Article 4.3ba of the Criminal Code. This measure may be imposed in the event of conviction for an intentional offense in the nature of the act, manner and circumstances of its commission allow it to be assumed that the offender has lost the qualities required to hold the military rank. Significantly, the punishment can also be imposed on the perpetrator who, even at the time of the crime, was no longer a soldier in active military service. The specifics of the proceeding conducted in the case of or against the perpetrators of the above mentioned military crimes can be discussed both in view of the fact that the same cases are conducted by separate bodies and in view of the different regulation regarding the procedure itself provided for by the legislator. Starting with the difference in the procedure in which military cases are dealt with, it must first be pointed out that in accordance with Article 646 of the Code of Criminal Procedure, in cases of military crimes, the possibility of using private prosecutions, warranted and expedited proceedings has been excluded. It is not difficult to imagine that this is due to the specific nature of military proceedings. However, in the case of an offense prosecuted from private prosecution, which is also a military crime, as soon as complaint is filed, an ex officio prosecution office. In addition, the military prosecution own motion for an offense prosecuted from private prosecution in the public interest so requires. If a military case is considered to be such a category of case, it does not lose its characteristic even if a soldier is discharged from active military service or the employment in the military before its termination. Exception is when, in the case of discharge of an offender from active military service or work in military, the military court itself concedes that it is reasonable to refer the case to a common court and the good administration of justice does not oppose it. The parts to the proceeding have the rights to appeal against such a decision. Article 649 of the Code of Criminal Procedure also regulates the conduct of proceeding and adjudication in the situation in which the perpetrator of a military crime is additionally responsible for the commission of a universal crime. This provision provides for the primacy of the organs of the military justice system, where in addition to the perpetrators of a military crime subject to adjudication by a military court, there is also a perpetrator who is not subject to that court's jurisdiction. It is possible to have such a case recognized in full by a military court and to have the case referred in whole or in part to a universal court for adjection. In the case of military crimes, of course, the question of local jurisdiction also had to be dealt with differently. The jurisdiction of the authority conducting the proceeding in the case subject to the jurisdiction of military court is determined by the question of the location of the military unit in which the soldier committed the crime was military service or employee was employed. The moment that permanently determines this jurisdiction is the moment of the commencement of the proceedings. In the case of so-called application offense, the entity authorized to initiate proceedings in the commander of the unit, and it is permissible for the military prosecutor to initiate proceedings also and without such a request if important consideration of military discipline required it. As a part of preparatory procedure, it is mandatory to obtain data on the course of the military service of the perpetrator, the distinction awarded to him, and disciplinary punishments. Interestingly, the data of the curative interview are collected and complied by a military social curator of the Article 662 of the Code Criminal Procedure. Such curators are professional soldiers in active service appointed at garrison courts by the presidents of these courts. Candidates for curators are submitted by commanders of military units. Differences in the procedures in cases subject to the jurisdiction of military courts related to coercive measures include the extension of the list of entities entitled to detain a person suspect of being a military superior and military law enforcement authority. In the analyzed cases, it is possible to apply temporary detention against a soldier exceptionally even when there is a legitimate fear that he will recommit one of the offenses consisting of. As to the form of proceeding in cases subject to the jurisdiction of military court, the investigation is conducted in cases of crime when in other cases where the gravity or complexity of the case so requires. Military justice. The institutional position of the military judiciary results from the regulation, first of all, of the constitutional rank, and then of the legislative rank, and regulation of executive act issue on the basis of law. Judges of military court enjoys all the rights, including constitutional guarantees applicable to judges of common courts and administrative courts. They also have the same rights and duties. The status of a military court judges does not differ from a status of a judge of common court or administrative court judge establishment in Constitution. The framework provisions regarding military courts contained in the Constitution are supplied by the regulation contained in the Act Law of the System of Military Courts. This act specifies the task of the courts, grants judges additional powers to complain soldiers serving in the military, and regulates the structure of military courts, the principles of their operation, and the procedure for appointing judges. Apart from strictly procedure issue relating to the internal functioning of the military court, it is worth at least briefly mentioning the structure of this court, which is different from the structure of common or administrative courts, but is crucial for determining the court competent to hear a given case. Military courts are military garrison courts and military district courts. Currently, in accordance with the decree of the Minister of National Defense, which in agreement with Minister of Justice and after consulting the opinion of the National Judicial Council, creates and abolished military courts. There are two military courts in Poland, military district courts in Poznań and military district courts in Warsaw. They are as well 7 garrison courts, military garrison court in Gdynia, in Lublin, in Olsztyn, in Poznań, in Szczecin, in Warsaw and in Wrocław. Military garrison courts are competent to adjudicate as courts of first instance in all cases except those which have been directly transferred by law to the jurisdiction of another court. With regard of the content of Article 654 of the Code of Criminal Procedure, cases have been transferred to the jurisdiction of military courts, firstly for offense committed by soldiers of the rank of major and above, secondly for offense which, if carried out in the ordinary court, would be recognized by the district court as the court of first instance, cases of desertion connected with flight from the country, and assault on a superior with the use of weapon, knife, or other similarly dangerous object, or assault resulting in serious or medium injury to health, and thirdly, for offense committed by soldiers and civilian personnel. The Supreme Court in Warsaw, the criminal chamber, is competent to decide on appeals against rulings issued by military district courts. Until 2017, these cases were heard by the military chamber in the Supreme Court, but this was abolished as part of the reform. The institution authorized to initiate, conduct, and supervise preparatory proceedings for crimes subject to the jurisdiction of military courts are the prosecutor's office and military police. The powers to give the final direction, shape, and decide on the outcome of the proceedings, both inquiry and investigation, belong to the prosecutors, referred to as prosecutors for military affairs. With regard to the last reform, which entered into force on April 2016 and introduced changes in the principles of functioning and organizational structure of the prosecutor's office, the separation of the military prosecutor office was abolished. The General Military Prosecutor Office, Military District Prosecutor's Office, and Military Garrison Prosecutor's Office were replaced, respectively, by the Department of Military Affairs on the National Prosecutor's Office, the departments in District Prosecutor's Office, and Department in District Prosecutor's Office. Importantly, in the course of the reform, the military prosecutors, who are soldiers, were somehow removed from the authority of the Minister of National Defense and transferred to the structure of the General Prosecutor's Office. These changes were combined, given the relatively low burden of cases subject to the jurisdiction of military courts, with the transfer of power to military prosecutors in cases outside the jurisdiction of military courts. Currently, prosecutors for military affairs operate within 4 departments: military affairs in District Prosecutor's Office in Poznań, Gdańsk, Warsaw, and Kraków, as well as 13 divisions for military affairs in District Prosecutors: Gdynia, Białystok, Bydgoszcz, Katowice, Kraków, Lublin, Łódź, Olsztyn, Poznań, Rzeszów, Szczecin, Warsaw and Wrocław. The Ministry of Justice has the authority to create and abolish these disorganization seals in the structure of unit of the prosecutor's office in agreement with the Minister of National Defense. Importantly, prosecutors who are professional soldiers or reserve officers are appointed to perform functions in organization units responsible for military matters. The military police is a separate and specialized service that is part of the armed forces of the Republic of Poland. Issues related to its structure and competence are regulated by the Act of the Military Police and military law enforcement bodies. In the scope of proceedings subject to the ruling of military courts, soldiers of the military police are authorized to conduct preparatory proceedings, including to independently perform evidentiary activities. The structure of the military police includes the main command, the branches of the military police, departments of the military police, and depending on the needs, also the station of military police. These units are created, transformed, and abolished by the Minister of National Defense. Currently, there are 7 branches in Poland and 10 departments now. And the summary: to sum up the issue discussed earlier, it should be noted that the so-called military crimes undoubtedly constitute a separate type of crime, and as a result, they are characterized by specific regulation introduced by the legislator. Firstly, in cases of military crimes, preparatory proceedings are conducted exclusively by soldiers from the military police and military prosecutors from the departments and divisions created in the general units of the public prosecutor's office. Secondly, they are exclusively subject to the jurisprudence of military courts, which are structurally distinct and independent from the general courts. Thirdly, the procedure in which so-called military crimes are recognized is regulated differently. And fourthly, regulation on penalties and punitive measures that may be imposed on the perpetrators by the court are different from common crimes.